Our first speaker tonight is Dick Peeples.
Thanks, Mike, and it's great to be here. This is going to be a lecture taking us back 40 years and really coming back to last year. Our primary topic, as Mike has said tonight, is the story of the Baker versus Wade litigation, which challenged Texas 2106 of the Penal Code. Two subsequent cases also challenged 2106, Morales and, of course, Lawrence, and I will address those cases as well. But before getting to the litigation, I think it's important to set the stage and give you a little flavor of what being gay or lesbian was like in the Dallas area in the mid to late 70s. In 1976, police regularly recorded the license plate numbers of cars at gay bars, a gay church, and meetings of gay people in Fort Worth. The Dallas Motion Picture Review Board established a new classification, P for perversion, for homosexual content. In June of 1977, Anita Bryant, spokesperson for the Florida orange industry, successfully led a referendum campaign in Miami-Dade County that overturned a non-discrimination ordinance passed to protect gays and lesbians. And here tonight, I want to publicly acknowledge and thank Anita Bryant for being the catalyst that got me fully involved in gay activism 39 years ago. I don't think she's dead yet, but she was certainly turned over in her grave. I mean, it's not just me. Many people across the country were also motivated by that event. In 1977 as well, DISD Superintendent Nolan Estes said he didn't think there were any gay or lesbians teaching in the schools, but if he found any, he would fire them immediately. Dr. Estes himself received quite an education about that. 12 people dancing on the Village Station dance floor were arrested by Dallas Vice Police and charged with public lewdness. Approximately half pleaded guilty, most likely for fear of public exposure, but the rest fought the charges. Several went to trial and were found guilty, others found not guilty. They weren't doing anything but disco dancing. In 1977, continuing into 78, uniformed police officers routinely entered gay bars, not in response to calls for assistance, but basically to intimidate patrons. On November 27, 1978, Harvey Milk, the first openly gay elected supervisor in San Francisco, and Mayor George Moscone were assassinated at San Francisco City Hall by fellow supervisor Dan White. White was found not guilty of murder by using what came to be known as the Twinkie defense. He was convicted of voluntary manslaughter, however, and committed suicide 7 years later. I had to look that up to find out for sure. As an aside, Milk had been in Dallas a few months earlier to speak at an educational conference co-sponsored by the DGLA. In 1978, the Dallas Morning News published an article about gay issues under the byline of Mike Williams. The paper was subsequently sued by a heterosexual attorney named Mike Williams for defamation of character. Of course, you could be evicted from your apartment and fired from your job. At that time, you can still be fired today. The Metropolitan Community Church existed in Dallas, but besides DGLA and a few bars, there were virtually no other gay or lesbian organizations or social outlets. On the other hand, it was the high days of disco. And Don Baker and I spent many an evening dancing to the pounding beat of disco music on the old plantation and later the Village Station dance floors. Finally, AIDS had not been publicly identified as a health concern. As Mike has already mentioned, pervading virtually all of these actions was the fact that gays and lesbians were criminals. 2106 of the Penal Code criminalized private sexual contact between consenting adults of the same sex. In 1976, the Dallas Gay Political Caucus, now known as the Dallas Gay and Lesbian Alliance, or DGLA, was formed. It had a small following. A typical monthly meeting might consist of 20 to 30 people. But membership and activities expanded tremendously in the months leading up to the Miami-Dade referendum. 300 to 400 people attended the meeting after the Miami vote, and attendance continued at high levels for a long time. The energy at these meetings was electric. At one, Steve Wilkins stood up and nominated himself for a board position. He was later elected president after that in early 1977. A few months later, I was elected to the board, as were Louise Young, Don Baker, and Vivian Armstrong. All of us were in our late 20s or early 30s. The litigation. About the same time, 1976 in Houston, the Houston Human Rights Foundation was being formed. A decision was made shortly thereafter to make the organization a statewide one. The name was changed to the Texas Human Rights Foundation, and in 1978, I was elected to the THRF board as the first member from outside Houston. I quickly got my Dallas gay brother attorneys, Mike Anglin and Lee Taft, elected to the board. And representatives were also added from Austin and San Antonio. At later times, B.J. Anderson, Bill Nelson, Alan Levy, and Worth Ross served on the board from Dallas. THRF was formed primarily to mount a legal challenge to 2106. Our objectives for the lawsuit were educating and empowering the gay and lesbian community, mobilizing and establishing contact among various gay and lesbian communities around the state, educating the community at large, and increasing the amount of public opinion in favor of ending 2106. As to fundraising, there were no mega events or mega donors. Events were tailored to local communities. Outreach was made to small towns in East Texas, the Panhandle, El Paso, South and Southeast Texas, in addition to the large cities of Austin, San Antonio, Houston, Dallas, and Fort Worth. For a number of events, admission was charged in the amount of $21.06. Strategizing for the case. To meet our objectives, we had to find a plaintiff who was both open and willing to interact with the press, but was also articulate and admired. Several of us on the THRF board had worked with Don Baker in DGLA, and Don was well aware of the plans for the case. Don consented to be the plaintiff. As such, he agreed to expose his identity and his private life to intense public scrutiny. This was no small sacrifice. At that time, Don Baker became one of only a handful of openly gay people in Texas. We next solicited for an attorney. We interviewed 2 finalists and were fortunate that Dallas attorney Jim Barber consented to take the case. I don't think any of us realized at that time that the case would drag on from 1978 until 1985. We carefully chose expert PhD degreed witnesses who had outstanding credentials in their fields and the subject of homosexuality. Judd Marmer, psychiatrist and former president of the American Psychiatric Association, William Simon, sociologist, and Victor Furnish from the SMU Perkins School of Theology, filing suit in the trial. We made an initial decision to file the case in federal court under federal law and not state law. We felt the climate was more favorable, particularly because of developing federal case law about privacy rights. The lawsuit was filed in late 1979 and named as defendants Henry Way, Dallas DA, and Lee Holt, Dallas City Attorney. But when Attorney General of Texas joined the case, the defendant class was expanded to include all district, county, and city attorneys in Texas responsible for enforcing 2106. The trial was held before Judge Jerry Buckmeyer in August of 1981 and lasted 3 days. I was surprised and impressed that Judge Buckmeyer had his pre-teenage son in the courtroom as an observer all 3 days. Those 3 days were an emotional and empowering event. It was also a bit scary because people attending could be assumed to be homosexual, especially for us attorneys. That could result in immediate firing. The testimony and some of Judge Buckmeyer's findings. Of course, Don Baker testified. About him, Judge Buckmeyer noted that he was a Boy Scout and a 4-year Navy veteran, honorably discharged. Baker was a, quote, very sincere, very credible witness. Nearly 5 pages of Buckmeyer's opinion described Don's life and his agony in dealing with his repressed homosexual feelings. I had the deepest admiration that Don was testifying in open court and really to the entire world about some of the most personal facts of his life. About Judd Marmer and William Simon, their qualifications as experts in the field of homosexuality were, quote, impeccable, and their testimony very credible. Two significant findings of facts that he made. First is what the judge called exclusive homosexuality is not chosen but fixed at an early age. It is not a disease and would be, quote, difficult and painful, if not impossible, to change. Second, that the existence of the law results in stigma, emotional distress, and can cause severe mental health problems. The primary witness for the state was psychiatrist James Grigson, who claimed that he primarily engaged in legal psychiatry. Grigson stated that because of the existence of the criminal sanction of 2106, $200 fine, homosexuals would seek out psychiatric treatment to be cured. The judge's comment on that was, quote, not only preposterous, but contrary to the facts. As to Buckmeyer's opinion of Grigson, quote, the court completely discount Grigson's testimony and opinions. His opinions are flawed, inconsistent, and directly contrary to the plaintiff's experts. Ruling and appeal. Judge Buckmeyer's ruling issued August 17, 1982, held that 2106 was an unconstitutional violation of the right to privacy and of equal protection. Quote, the right to privacy therefore does extend to private sexual conduct between consenting adults, whether heterosexual or homosexual, and any regulation of this fundamental right must be justified by compelling state interest. Quote, the defendants did not produce a single witness or any other evidence to support the alleged state interest of morality and decency, welfare and safety, and procreation. Finally, I want to quote footnote 53 from the opinion. From the testimony of the plaintiff, Donald F. Baker, about his life, the reluctant, painful recognition of his homosexuality, his disgust and self-loathing and fear, his isolation and suffering, and the eventual reconciliation of his, quote, exclusive homosexuality with his devout religious beliefs and family values, it is evident that Baker's resulting decisions concerning his sexual needs and desires are of the most personal, intimate, and important concern, just as they are for heterosexuals. The Buckmeyer opinion is a comprehensive and well-written document on the state of the law in 1982. Cedar Springs was closed off so hundreds could celebrate with partying and joyous emotions. And for several years, Gay Pride in Dallas was celebrated in August to commemorate this ruling. Appeal to the Fifth Circuit. After the Dallas DA and Attorney General Jim Maddox both chose not to appeal the ruling, Amarillo DA Danny Hill sought to intervene and appeal on behalf of the expanded defendant class. Buckmeyer denied the ruling. Maddox asked the Fifth Circuit to disallow Hill's appeal. Quote, a contrary position by this court would make litigation on behalf of the state wholly unmanageable by allowing 315 district and county attorneys and 736 state agencies to assert their own positions. Initially, a three-judge panel from the Fifth Circuit agreed and ruled against Hill. But the full Fifth Circuit voided that ruling and in August of 1985 issued an en banc, or the entire court ruling, on a vote of 9-7, which reversed the Buckmeyer opinion. The majority said that Danny Hill had the right to appeal. The majority then ruled that, quote, engaging in homosexual conduct is not a constitutionally protected liberty interest. On the equal protection issue, the court held that, quote, listen closely to this, in view of the strong objections to homosexual conduct prevailing in Western civilization for at least the past 7 centuries, the court cannot say that 2106 is totally unrelated to the pursuit of implementing morality, which is a permissible state goal. Judge Rubin wrote a blistering dissent at the Court of Appeals, which started, determined to uphold the constitutionality of a Texas statute, whatever obstacles bar the way, the majority opinion tramples every procedural right it considers. And later, quote, if this en banc decision is precedent, it most assuredly rewrites the adjective law. If it is not intended to be precedential, but only a special life support contrivance undertaken for the one purpose of salvaging the statute, it denies equal protection to the litigants before us. Bowers versus Hardwick. The Hardwick case was progressing through the federal courts in Georgia at the same time as Baker. In 1982, Hardwick was arrested for consensual sodomy in his bedroom, but the Atlanta DA chose not to press charges. Hardwick then, together with a married couple, filed suit seeking a declaratory judgment that the Georgia state sodomy statute was unconstitutional. The district court denied the suit, but a panel of the 11th Circuit reversed, finding the law unconstitutional. The Supreme Court agreed to hear the Hardwick case because of the conflicting Fifth Circuit decision in Baker. The Supreme Court issued its ruling on June 30, 1986, voting 5-4 to uphold the sodomy statute as to homosexual activity. We were very disappointed that Hardwick reached the Supreme Court before Baker. We felt that Hardwick did not have the evidentiary record that Baker had, nor did it have the detailed and thoughtful legal analysis and opinion that Buckmeyer wrote. Finally, Hardwick did not have the equal protection issue. Nevertheless, the Supreme Court refused to hear the appeal of the Baker case. The final outcome of Baker was a setback. However, for the first time, for a 3-year period from August of 82 until August of 85, gay and lesbians in Texas were not criminals. It felt good, by the way. Morales versus State of Texas. 4 years later, in 1989, THRF found 5 well-known plaintiffs, Linda Morales, Tom Doyle, Patricia Kramer, Charlotte Taft, and John Thomas, who were carefully chosen to represent the genders and provide ethnic diversity. The goals for the case were the same as in the Baker case. The plaintiffs traveled the state extensively. This time, 2106 was challenged under the Texas Constitution as violating the right to privacy, equal protection, and due process. We won in the district court. In March of 1992, the Austin Court of Appeals affirmed the district court's conclusion that the law was unconstitutional. The court found no cases directly involving a prosecution under 2106 since the statute was enacted in 1974. It also noted that the state stipulated as to the harm of the law. It implicitly condoned hate crimes, encouraged discrimination in the legal system, and raised the threat of arrest, fine, and pecuniary loss. In addition to branding gays and lesbians as criminals, 2106 legally sanctioned discrimination in employment, family relations, and housing. The Court of Appeals stated that while the state of Texas offered the implementation of public morality as the sole compelling objective for the law, it offered no evidence that 2106 in any way advanced public morality. In addition, the court declared that it was disingenuous for the state to suggest it was protecting public morality when it conceded that it rarely, if ever, enforced the law. The opinion observed that the state did not argue public health as grounds, nor was there any evidence in the record or in the legislative history that 2106 was intended as a disease prevention measure. Finally, the court noted that heterosexuals engaging in the types of conduct described in 2106 would have the same risk of disease. In conclusion, the Court of Appeals ruled that the state did not meet its burden of showing a compelling state interest and found 2106 violated the right to privacy. It did not rule on equal protection or the due process claims. In January of 1994, the Texas Supreme Court, in another 5-4 decision written by John Cornyn, ruled that the civil courts did not have equity jurisdiction in a case involving a criminal statute such as 2106, therefore the case was thrown out. The court did note that the Texas Attorney General conceded that the statute had not been and would not likely be enforced. Observations about the Baker and Morales cases. Don Baker and the Morales plaintiffs made gays and lesbians real to many Texans. The stigma and pervasive nature of the impact of 2106 became clear. And I think most importantly, thousands of LGBT people became involved in their communities, joining existing organizations and establishing new ones. Editorials from newspapers in Dallas, Austin, San Antonio, Houston, and San Angelo call for the repeal of 2106. In 1981, when the Baker trial occurred, little was known about AIDS. Time magazine had published a short article about a disease called GRID, gay-related immune deficiency. Sadly, all of that changed quickly in the years following. Liberty protects the person from unwarranted governmental intrusions into a dwelling or other private place. In our tradition, the state is not omnipresent in the home, and there are other spheres of our lives in existence outside the home where the state should not be a dominant presence. Freedom extends beyond spatial bounds. Liberty presumes an autonomy of self that includes freedom of thought, belief, expression, and certain intimate contact. The instant case involves liberty of the person both in its spatial and more transcendent dimensions. This paragraph is how the 2003 United States Supreme Court opinion written by Justice Anthony Kennedy begins in the case of Lawrence versus Texas. The facts presented the court with an actual arrest and charge under 2106. Justice Kennedy first reviewed the development of, quote, liberty rights in prior Supreme Court cases. As an aside, and this is just my opinion, many prior court cases, including Baker, used the concept right to privacy instead of liberty. But the term right to privacy does not appear in the Constitution, and the courts had a hard time finding out where it came from. But the term liberty does occur in both the Fifth and 14th Amendments. Kennedy then re-examined the holding in Bowers versus Hardwick. According to Kennedy, the Bowers court framed the issue to be decided as, quote, whether the federal Constitution confers a fundamental right upon homosexuals to engage in sodomy and hence invalidates the laws of many states that still make such contact illegal and have done so for a very long time. Quoting Kennedy again, that statement, we now conclude, discloses the court's own failure to appreciate the extent of the liberty at stake. To say that the issue in Bowers was simply the right to engage in certain sexual conduct demeans the claim the individual put forth, just as it would demean a married couple were it to be said that marriage is simply about the right to have sexual intercourse. Quote, the laws involved in Bowers in here are, to be sure, statutes that purport to do no more than prohibit a particular sex act. Their penalties and purposes, though, have more far-reaching consequences, touching upon the most private human conduct, sexual behavior, and in the most private of places, the home. The statutes do seek to control a personal relationship that, whether or not entitled to formal recognition in the law, is within the liberty of persons to choose without being punished as criminals. Justice Kennedy, speaking for a 5-4 majority, stated that, quote, Bowers was not correct when it was decided, and it is not correct today. It ought not to remain binding precedent. Bowers versus Hardwick should and now is overruled. Close quote. While Justice O'Connor did not join in voting to overrule Hardwick because she was one of the 5 members of the Hardwick majority, she did vote with the Lawrence majority to void 2106 on equal protection grounds. Thus, the vote to void 2106 was a 6-3 vote. Finally, wrapping up near the end of the opinion, Kennedy says, the petitioners are entitled to respect for their private lives. The state cannot demean their existence or control their destiny by making their private sexual conduct a crime. Their right to liberty under the Due Process Clause gives them the full right to engage in their conduct without the intervention of the government. It is a promise of the Constitution that there is a realm of personal liberty which the government may not enter. The Lawrence decision was announced on June 26, 2003, and it ended the era of criminalization of private sexual conduct of lesbians and gays. We celebrated our community victory late into the night that night. For non-lawyers here, what happened in the Lawrence opinion is truly amazing and happens very rarely. A mere 17 years after the Bowers decision was issued, the Supreme Court overturned that ruling in Lawrence with very strong and forceful language. Now, why am I reading from the Lawrence opinion in a presentation about the Baker and Morales litigation? Well, first, Justice Kennedy's opinion is incredibly powerful and emotional, and I reread it periodically to remind myself of the affirming language and the principles it contains. But also, in my opinion, the ruling in Lawrence was facilitated and supported by using records contained in the Morales opinions. And Morales would never have happened without the original Baker versus Wade litigation that came before it. The trial and appeal records in Lawrence were much less detailed than those in Morales. But because of the admissions by the state of Texas recorded in the Morales opinions, Justices Kennedy and O'Connor could use those admissions again in Lawrence. Justice Kennedy noted that Texas admitted in 1994 that there had been no 2106 cases with respect to consenting adults in private. Justice O'Connor cited the admission by Texas of legal sanctions against homosexuals unrelated to criminal law, such as employment, family laws, and housing. She also cited the state's admission that 2106 branded lesbians and gay men as criminals and therefore legally sanctioned other discrimination against them. In conclusion, the lengthy Baker versus Wade litigation process is a central chapter of Dallas LGBT history. It expanded and strengthened our community, and it moved us down the winding road that has culminated in the Supreme Court rulings in Lawrence, and then, of course, on June 26th of last year in Obergefell. Thank you.